Hello, everyone. Thank you for attending this webinar. I'm Fang Sun from IP Consulting Department of SPTL. Our department is in charge of patent search and analysis affairs. We gained rich experience in patent infringement search, invalidity search, and patent landscape. At this time, one of our senior attorneys, Mrs. Ma, will introduce the punitive damages in the new patent law of China and the specific FTO search in China. Mrs. Ma joined SPTL nearly 8 years. She has a wealth of experience in the field of aerospace, mechanics, and material. She practice primarily involves patent prosecution, patent validity, risk assessments, and IP due diligence. Her presentation will last about 30 minutes, and we will provide 15 minutes for questions. You may raise your questions during the presentation or can send your questions by email. Now let's welcome Mrs. Ma.
Okay, thank you for your introduction. Hello, everyone. Today, we will talk about punitive damages and the FTO in China. There are 4 parts of today's webinar. First, we will go through the legal basis of punitive damages system related to intellectual properties in China. Then, we will talk about constitutive requirements of punitive damages. In the third part, what's the relationship between punitive damages and FTO? Why FTO analysis is so important? What factors should be taken into consideration in doing FTO analysis? These questions will be discussed. And at last, some tips and examples for a comprehensive FTO search in China will be given. Now, let us start with punitive damages system in China. Punitive damages, which are also called exemplary damages, is compensation determined by a court in excess of actual loss of the right owner. The system was originally from UK in the 18th century, and now it is already adopted in United States, Japan, South Korea, and a lot of countries in the world. In recent years, in order to strengthen the protection of intellectual property rights and to deter infringers, punitive damages system also has been gradually introduced in China. In 2013, punitive damages was firstly introduced in trademark law, wherein Article 16.3 provides where the exclusive right to use a registered trademark is infringed maliciously and the circumstances is serious, the amount of damage may be more than 1 time but less than 3 times the amount determined by the referring to the above calculation. Then, the first amendment of trademark law in 2019 increased the multiple of punitive damages from more than 1 time but less than 3 times to more than 1 time but less than 5 times. In the same year, the third amendment of Anti-Unfair Competition Act also introduced the punitive damages system. The multiple of it is more than 1 time but less than 5 times. In the year of 2020, the amended patent law and copyright law, which already have been put into effect on June 1st this year, also include the punitive damages system, and the multiple of it is more than 1 time but less than 5 times as well. In March of this year, the Supreme People's Court issued 6 cases about punitive damages system in IP cases as typical cases, which are shown in the table. The cases are related to trade secrets, trademarks, and anti-unfair competition. The multiple of punitive damages is from 2 to 5 times. From all the typical cases mentioned before, two constitutive requirements are taken into consideration to determine whether punitive damages should be applied or not, which are from the subjective aspect, whether the act is intentional infringement or not, from the objective aspect, whether the circumstances is serious or not. On March 3rd of this year, the Supreme People's Court issued interpretation on the application of punitive damages in trial of civil infringement cases of intellectual property rights. The interpretation makes a specific provision on the application scope of punitive damages and the determination of intentional infringement and serious circumstances. In Article 3 of the interpretation for determination of the intentional infringement, the factors should be included the factor included the type of infringed intellectual property rights, the rights status, and the popularity of the products. The relationship between the defendant and the plaintiff or the interested party should be comprehensively considered. The interpretation provides the following situation where the intentional shall be determined. 1. The defendant still commits the IPR infringement after being notified or warned by the plaintiff or party of interest. 2. The defendant or its legal representative or manager is the legal representative, manager or actual controller of plaintiff or party of interest. 3. The defendant has work, label, corporation, license, distribution, agency, representation, or any other relationship with the plaintiff or party of interest and has been in contact with infringed IPR. 4. The defendant has business relations with the plaintiff or party of interest, or has any consultation with the plaintiff or party of interest for the purpose of reaching a contract, among others, and has been in contact with the infringed IPR. 5. The defendant commits any act of piracy, of counterfeiting any registered trademark. Now you may be wondering, what's the relationship between the punitive damages and FTO? First, let us take an example case in the United States. In the case of Underwater Device versus Morrison Knudsen in 1983, U.S. Court of Appeals for the Federal Circuit held that if a potential infringer has actual notice of another's patent's rights, he has an affirmative duty to exercise due to the care to determine whether or not he is infringing. Such an affirmative duty includes, inter alia, the duty to seek and obtain competitive legal advice from counsel before the initiative of any possible infringing activity. From the case law, FTO analysis is a means to avoid punitive damages due to willful patent infringement in the United States. Then, how about China? Since the new patent law is just put into effect for several months, there are no typical cases at this moment. Let us first clarify some definitions under the practice of civil law to see whether FTO analysis can avoid punitive damages or not in China. As we already mentioned before, one of the constitutive requirements of punitive damages is intentional infringement. In the practice of civil law, intentional can be further divided into directly intentional and indirectly intentional. Indirectly intentional means the psychological states of knowing one's own behavior may cause harm to the society and to allowing the harmful result to happen. In the patent case, if one knows the product may infringe a patent right, but do not take any preventive measures and allowing the infringement to occur. Such activity may be determined as indirectly intentional and constitute intentional infringement, which leads to punitive damages. As we all know, the main purpose of FTO is to make sure that it is commercially safe when a product enters into a new market. On one hand, at least FTO analysis can prove that one has taken the preventive measures and does not allow the harmful result to happen if there may any. And on the other hand, if FTO analysis has not been carried out, once infringement is found, there is a chance that will be considered as intentional infringement. Thus, from this point of view, an FTO analysis could be a means to somehow avoid the punitive damages. Then, how to get a qualified FTO report in China? First, find the right person to do the analysis. In China, patent agents are divided into general patent agents and patent agents with litigation qualification. Attorneys are divided into attorneys with patent agent qualification and other general attorneys. We recommend a patent agent with litigation experience or an attorney with patent agent qualification to do the FTO analysis. In other words, we recommend a professional with both patent prosecution and litigation experience. Since if the person only has the patent prosecution experience or he is a general attorney, then their experience probably are not enough to do such an analysis. And in the end, the conclusion of the FTO report would be doubted by others. Second, we should know what are the contents should be included in a qualified FTO report. The report should at least include legal investment, a summary of invention, FTO search strategy, a summary of FTO search, a list of patent documents which have been analyzed, results of FTO analysis, and conclusion. In the legal investigation part, this part should include the patent law, the relevant interpretations, etc. And in the summary of the invention, this part provides a brief summary of the invention. It includes the essential features, the technical information used for the FTO search, how to use the products, which country or countries the product will enter, and the time frame of each country, and so on. And in the FTO search strategy part, this part should include the database searched, countries and patent office searched, languages used for the searching, time limits, types of patent documents searched, subject matter searched, search terms, and the patent classification that we used for the searching. The summary of the search terms can be displayed in a table. Then it's a summary of the FTO search. In this part, it should provide a brief summary of the search result. For example, how many documents was found, how many potential relevant patent documents were identified as potentially relevant patent documents and selected for further analysis, what are the criterion for identifying a search result as potentially relevant patent document and selecting it for further analysis? Is there a specific criterion to identify some of the search results as not potentially relevant and exclude them from the further analysis? And this kind of information should be provided in this part. Then the result of the FTO analysis. In this part, it should list all the patents that were identified as potentially relevant and selected for the further analysis. The analysis of each patent should include the information data and the legal status. For each patent, at least the independent claims should be analyzed. The protection scope of each independent claim should be determined, and the technical features of each independent claim should be compared with the invention and determine whether the invention falls into the scope of the protection of the claims. Then the last part is the conclusion. In this part, it should include the limitations and the risks associated with the process, the general remarks, and the remarks that are specific to this project. As you already know from the previous part, the very important factor to get a qualified FTO search is to get a comprehensive FTO report to get a comprehensive FTO search. Based on the statistics of Zen IPR, till the end of June of 2021, there are 2.454 million valid patents, including invention, utility model, and design in China. With such a huge amount of patents, on the other hand, that is very important to assess the risk when the product enters into Chinese market. And on the other hand, that is also a challenge to conduct a comprehensive FTO search in China. Here, we would like to provide you some tips on FTO search in China, mainly about the database and for searching and the keywords of the search strategy. It is well known that normally the classification and the keywords are used in the search strategy. The classification could include IPC, CPC, F-terms, and extra, and the keywords which depends on the person who conducts the search. Original languages or English or other languages will be used. Here, strongly recommended to use original language of the documents. Since every language is very different, especially the languages from different language family, the translations are not very accurate. When it comes to the technical terms, it may be even more complicated. Let us look at 4 small examples to show why using Chinese as keywords in FTO search for Chinese documents is so important. The first example, which called IPC is not enough. Let's look at the Chinese application. In the front page, it stands the IPC of the application is G05B19/42. Then we look up the IPC classification. As you can see, this classification stands for Program Control Systems using digital processors. Let us move to the independent claim of this application. The independent claims is to protect a self-powered switch. We read the claim further. The switch comprises control panel, a switch pan, and a micro generator. The micro generator is used to transform mechanical energy into electrical energy to power the control panel. From the subject matter of the claim, the application has nothing to do with the program control systems. If this application is a document which should be included in our search results, but we only use IPC for the search, the application will not be hit, since it is likely that the examiner classified the application into the wrong classification. By using the reasonable keywords, such a situation could be avoided. Then is a second example, which is search in Chinese. Let's try to search concrete in title for Chinese patent documents. We use the database patent scope. which is provided by WIPO, and both English and Chinese can be searched in this database. Now first, we try the English words concrete in the title. The hit number is 108,792. Then we look up the dictionary and find the Chinese for concrete. As you can see in the dictionary, there are 3 Chinese characters for concrete. Then we put the 3 Chinese characters in the title, and the hit number is 134,478 records. From English concrete to the Chinese concrete, that's 3 Chinese characters, the hit number increased by 24%. Since Chinese is very different from English and belongs to a very different language family, it is better to use Chinese as keywords to do the Chinese documents search. If only English is used for searching Chinese documents, quite a number of the documents will be missed. Then let's move to the third example. The third example will talk about technical terms in Chinese. From the example 2, we already know that there are 3 Chinese characters stands for concrete. Unfortunately, there is a technical term which called tong in Chinese, also stands for concrete. And it is quite difficult for a person who is not skilled in the arts to know this technical term. Let us see what will happen when we use the 3 characters as the search term and the 3 characters plus the technical term in patent scope. As you can see, only 7 documents added in the result. It seems the difference is not so big. And how about we try another database? Here the database Zen IPR is introduced. It is an official publisher of Zen IPA, and it is quite updated. As you can see today, the data coverage today is 23rd September, and the data already covers the documents published on 21st September. Then we try that 3 characters and 3 characters plus a technical term in Zen IPR. As you can see, 9,808 more documents are hit, and the hit number increased by 7.1%. From this example, it shows that it is very important to include the technical terms for the searching. Then it's the last example. Choose the right database. Let us compare the difference of the hit numbers between patent scope and the Zen IPR. In the both database, the Chinese concrete, that 3 Chinese characters is used as a search term. In patent scope, 134,487 documents are hit, while 138,782 documents are hit in Zen IPR. The hit number increased by 3.2%. Then let's try the Chinese concrete, that 3 Chinese character plus the technical terms of concrete in Chinese in patent scope and Zen IPR. The result is 40,096 more documents are hit, and the hit number increased by 10.5%. In this example, it shows that using the identical search strategy in different databases especially more search terms included, the difference could be huge. Now it's nearly at the end of our webinar. Let us go through the last part of today's sharing. Today we talk about the punitive damages system in China, and the system is already widely adopted in IP cases in China. As we all know, the punitive damages are determined by intentional infringement and serious circumstances. There is one way to avoid intentional infringement in patent cases, which is a qualified FTO analysis. Then, how to get a qualified FTO report in China? Find the right professional with both prosecution and litigation experience to do such analysis, and make sure that the contents of the report are probative. At last, two fundamental tips of FTO search in China are given, which are search in Chinese and choose Chinese databases. Now it's the end of our sharing, so do you have some questions?
Okay, thank you for your sharing, Mrs. Ma. I believe we now have a preliminary understanding of China's punitive damages system and FTO in China. Now let's see if anyone has questions. If you have any question regarding this topic, please raise your questions through the text message box. Okay, here is one question from Olive James. His question is, as you mentioned in the slide, the maximum multiple of punitive damages is 5 times. What is the reason for this?
Thank you for your question. Indeed, 5 times is a very high standards in current patent infringement compensation system among the world, which also shows China's determination to protect patents and ensure IP-friendly business environment for all the investors and the technical collaborators. This could be one reason. And another reason, it could be the amount of the patent infringement compensation in China has been low for quite a long time, which has a bad impact on punishing the patent infringers. Taking the patent infringement cases before the implementation of the new law and the maximum legal compensation and the relevant provisions of other civil and commercial laws. And this kind of factors into consideration. So the relative high standards was set.
Thank you for sharing. Let's see. There is another question from Will Hack. His question is, besides Zen IPR, could you give more suggestion about choosing the Chinese patent database?
Besides the Zen IPR, there are quite a number of Chinese patent databases. For the general technical fields, like the IncoPat or PatSnap are nice choice, and they are more user-friendly, and different ways for searching can be performed in this database, such as semantic searching. But since they are commercial databases and provides more user-friendly interface, and they have more functions, so the membership is probably higher than Zen IPR. And for some specific fields like biology or some medicine related, there are specific database available in China.
Okay, thank you. Any more questions? It seems there is no more questions at the time being. If you have further questions after the webinar, you can send it by email. Okay, at last, thank you again for Mrs. Ma's sharing, and thank you all for attending. Goodbye, and see you at the next webinar.